Nothing is always, and some wrecks are nearly impossible to defend. Help us understand some of those lines.
And I know the graphic's going to pop up there and say, you know, that's a sure thing, but really, no, there's, you know, people think of a rear end collision as being, you can't lose that.
It's always the fault of the guy
supposed to be.
behind.
And then what about if somebody turns left in front of you? That seems like that's
clear cut. Seems like
yeah. Well, let's take both of those for example. Suppose it's night, you have no taillights, and somebody
the guy behind hits me.
You're not going to recover more than likely.
Interesting.
And then what if somebody turns left in front of you, but you're speeding? You're probably not going to recover.
Too.
So. And when I say recover, I mean win the lawsuit. So now DUI crashes, that's a little bit different. It's almost like it doesn't matter what the facts are because people are so prejudiced, and rightfully so, against a DUI driver.
Has that prejudice been built up over time, greater today than ever before? Did used to people kind of get off a little easy? They'd been drinking a little, but they'd get away with it some.
Right, and I think that resulted in people being more strict. You hear all these stories about he had 7 prior DUIs. Well, how in the world did he have his license?
Yeah.
And so that was 20 years ago. But now, with Mothers Against Drunk Driving, people are just very conscious now of don't get behind the wheel of that 6,000 or 7,000 pound car, or, hey, 60,000 pound, 70,000 pound 18-wheeler. When you're either taking pills or drinking alcohol.
I'll ask one more question in this area. The injuries to a person that is seeking recovery, those have to be medically proven. That's why you always tell people to go to your doctor, go to the emergency room, get checked out. But do people that are trying to defend a client sometime argue that, oh, they're not hurt as bad as they're acting like they are, and ask for more proof? And is that something that's usually argued about in court?
Yes, practically always. Either directly or inferentially. You know, they'll make an inference and imply it. So, yes. And unfortunately, some plaintiffs do try to stretch their injuries. But what I found is if you downplay, you know, if you're going to make an error to the downside, and you'll be rewarded. But if you try to stretch it, that's the worst thing you can do.
Both in evidence and testimony, just tell the truth.
Tell the truth.
Just tell the truth. That'll be best for everybody.